All right. Hey, good afternoon. As promised, we are going to be listening out for that decision. Uh, Police Service Commission versus Paul Slowe versus the Secretary, I believe, of the Police Service Commission. And it's going to be a big decision. As you know, the former chairman of the Police Service Commission, Paul Slowe, took the installed president to court. And so this is the decision. Uh, Spread the word and share the link as we um, have about 5 or 10 minutes remaining before then. So it gives you guys some time to share the link. Indeed. All right. So in the interim, what else is happening? Let me just say, acknowledge you guys online, Winston Henry and others. Winston is watching us from East La Penitence. That's the Cooperative Republic of Dubai, Guyana. Sorry, um, Guyana. Some people are brazen enough to say Dubai, right? Um, so I am definitely not putting that beautiful country down, but it's difficult to see how it can be a Dubai, a small, a mini Dubai or Dubai under this questionable regime. Um, okay, so again, good afternoon to you guys. Thank you so much for sharing the link. I'm sure you can do some more sharing and welcome you to what's happening at this time. Paul Slowe, the decision, the Police Service Commission, as you know, he was chairman of the Police Service Commission, and the folks in the installed regime wanted him out so that they can put um, their political operatives in terms of senior positions within the Guyana police force without any proper scrutiny. And so they weren't concerned as to the individuals that they will promote. And I think that's what Paul Slowe was trying to ensure, that the proper men and women in uniforms are promoted. And of course, Mr. Paul Slowe, who was on this program yesterday, admitted that he was summoned to Irfan Ali's office, and Irfan Ali, according to Mr. Paul Slowe, made some uh, questionable requests of him. And it is my usage of the word questionable request. And so this decision today is an interesting decision. It's important. So please do spread the word as we prepare to share that news with you guys. But in the meanwhile, this is what Jack Deere is saying. Jack Deere, again, I don't know why they continue to describe this man in terms of giving him a title as a doctor. He's not the recipient of a PhD. This is an honorary degree, an honorary doctorate. You do not use it in this manner at all. He hasn't earned his PhD. He didn't go to school for that. It's an honorary. And I've noticed that the media houses in Guyana, they just use that willy nilly. And so they put doctor. In fact, he's not. Again. So, anyways, this guy is saying many factual errors in State Department's human rights report. Of course, they are going to jump out and they're going to say factual errors because that report has hurt them. We know that's a fact. Let us see what he is like. He is trying to gain some points. He is claiming, according to their propaganda news outlet, is that the report says the government took steps to identify, prosecute, and punish officials who committed human rights abuses or engaged in corruption. Now, we can take umbrage with this particular part of the human rights report because there is no evidence, none whatsoever, unless Jack Deere or anyone could point in the direction that this installed regime that rigged its way into office took steps to punish officials who committed human rights abuses or engaged in corruption. If we can have Lemon just remove that off, please. Remove it for a quick second. Punish officials who are engaged in corruption? You name one individual, one quote unquote official who was punished as a result of corruption in the installed PPP regime. And this is what Jack Deere is highlighting as a success story. Again, let me show you guys if you think I'm kidding you. First of all, he says, many factual errors in State Department's human rights report. Of course, factual error indeed. Number one factual error. The State Department report is claiming, number one there, that the install regime, they say the quote-unquote government took steps to identify, prosecute, and punish officials who committed human rights abuses or engaged in corruption. There's so many quote-unquote ministers or officials in the installed PPP regime who have committed human rights abuses, and no steps were taken. Absolutely no steps were taken to punish those individuals. The other thing, well, I'm kind of like, I'm not sure if you guys picked up on this one here, but according to Jack Deere, he is agreeing that the U.S. human rights report, that they are correct, that the quote-unquote government punish officials who engaged in corruption. Jack Deere has got to be kidding me. All right, so the human rights report, U.S. human rights report, didn't get that correct. They have other stuff correct in terms of the human rights abuses, in terms of police corruption and cover-ups and all these manner of things. They got that right. But Jack Deere is actually saying that he agrees with the human rights report, the U.S. human rights report, that there were steps taken to punish officials involved in corruption. Well. Jack Deere, if you're watching, and you don't have much to do, so I'm sure you might be watching, what about this?
Source. Okay, well, maybe the Chinese company that did not get the agreement that they wanted here, maybe they're the ones who told you. Or it could be just a fictitious thing.
Okay, well, let's talk about specific individuals. What is your relationship with Mr. Sudero?
So my relationship? Nothing.
Precisely. Nothing was ever investigated. Jack Deere promised, he said publicly, that he wants an investigation. He never went into Soku. He never surrendered. He never said to himself that, look, he wants this thing cleared up. He never did. Irfan Ali promised that there will be an investigation. And then suddenly we hear we can't find Sue. They can't find Sue. But I, thousands of miles away, I was able to get in touch with Sue. How long have you been living at Jack Deere's house?
The people just, I don't know what them doing. They never do nothing there. You understand?
Yeah. So how long have you been living at Jack Deere's house?
Huh?
How long have you been living at Jack Deere's house?
Hello?
Yeah. How long have you been living at Jack Deere's house?
For 1 year now.
Okay, so how much rent do you pay every month?
I pay 1.2.
1.2 million Guyana dollars?
Yeah.
Now when Vice News interview you, did they put you on camera?
No.
Did they record you?
I don't know nothing there.
Okay, so do you know?
I don't know what them do it.
Oh, so you don't know?
No, I don't know nothing there.
So why would they lie? Why would they lie on you? Are they lying on you, Mr. Sue?
I don't know why he lies for me. Them people claim to place. I don't know. It's no true. I tell you, 100% no true. They not think this. Yeah, sir, what's that?
So did you, when you met with Mr. Jagdir, because he met you, he called you over, what did you guys discuss?
No, just the people come invest in Kerala. So that's it.
So, and you issued a statement. Who wrote the statement for you in English?
I get the translator. Okay?
I got you. So
Yeah, thanks.
who,
Yeah.
let me ask, before you go, Mr. Su, before you go, the APNU code, Mr. Su there, right?
In the matter of Police Service Commission and another, and Secretary to the Police Service Commission and other, His Honor Justice Gina Prasad presiding. All parties are kindly asked to turn on their cameras and keep your microphones mute.
Good afternoon, everyone. Appearances, please. Good afternoon, please, Your Honor. Dexter Smart. I appear alongside Mr. Selwyn Peters and Mr. Dexter Todd for the entire judgment. No, because it's about 50 pages. So what I've done is I've summarized the essence of the ruling. So we will treat this as an oral delivery, which is a summary of the reasons for my decision, and a formal written judgment will follow. All right? If at any time any of the lawyers on record have a difficulty hearing, just give me an indication, please. This is a challenge by way of judicial review of a decision by His Excellency, the President of the Cooperative Republic of Guyana, to suspend the chairman and members of the Police Service Commission in June 2021. The Police Service Commission is a constitutional commission. Therefore, it enjoys a special legal nature with constitutionally protected security of tenure and a carefully crafted, sequenced process of removal from office. It is not a statutory body simpliciter. On the chairman and members of such constitutional commissions, the Indian Supreme Court has said the character and conduct of the chairman and members of the commission must be like Caesar's wife and be beyond reproach. They occupy a unique place and position and utmost objectivity in the performance of their duties, and integrity and detachment are essential requirements expected from the chairman and members. The suspension from constitutional office on the 16th of June 2021 proved tantamount to a removal from office, since the tribunal, the quasi-judicial body responsible for recommending such removal from office to the president, contemplated by Article 225(3) of the Constitution, was never constituted. In fact, it could not have been constituted, since the tribunal is appointed after the President acts in accordance with the advice of the Judicial Service Commission, and there has been no Judicial Service Commission in existence since 2017. In fact, a new chairman of the Police Service Commission was sworn in on the 31st of May 2022. The term of office of the suspended chairman and other members came to an end on the 8th of August 2021. The Constitution sets out a carefully sequenced process of removal from office. The several provisions of Article 225 can essentially be summarized as follows. 1. The prescribed authority advises the President that the question of removing the officer from office ought to be investigated. 2. The President shall then act in accordance with the advice of the Judicial Service Commission in appointing a tribunal. 3. The tribunal shall inquire into the matter and report on the facts thereof to the President and recommend to him whether the officer ought to be removed. 4. The President, acting in accordance with the advice of the prescribed authority, may suspend the officer from performing the functions of his office if the question of removal has been referred to a tribunal. 5. The officer shall be removed from office by the President if the tribunal has recommended to the President removal from office for inability to discharge the functions of his office, whether arising from infirmity of the body or mind, or any other cause whatsoever, or for misbehavior. This has been described as a very cumbersome process by the Indian Supreme Court. The single issue for determination is whether the suspension was lawful or not, whether the President acted ultra vires the Constitution or not. Since this is a judicial review case, the court is sitting in its supervisory jurisdiction to examine the legality of the President's decision to suspend the holders of constitutional office. Judicial review is an interrogation of the legality of the decision, how it was made, and whether it was reasonable and fair. Given the factual and legal parameters of this case, it can be said that the substantive ground for judicial review of the decision to suspend is illegality. It is the case for Slowe that the decision to suspend was unlawful and ultra vires the Constitution. In determining the issue of whether the suspension was lawful, ancillary issues and constitutional rights such as the protection of the law, due process of law, reasonableness, fairness, necessity, among other things, have to be examined. On the 19th of July 2021, the Police Service Commission instituted proceedings in the High Court by way of fixed date application against the Secretary of the PSC, the Commissioner of Police, the President of the Cooperative Republic of Guyana, the Prime Minister, and the Attorney General, seeking the following reliefs. 1, a declaration that the purported suspensions of the chairman and members were contrary to, in violation of, and ultra vires the Constitution. 2, a declaration that the Commission is presently constituted by its chairman, Paul Slowe, and other commissioners, Michael Somersall, Claire Jarvis, Vesta Adams, and Clinton Conway, remains competent and responsible to fulfill its constitutional mandate, including appointments to any officers in the police force of or above the rank of inspector. 3, a declaration that the Prime Minister's recommendations to His Excellency the President, dated 15 June 2021, that the question of removing the chairman and other commissioners from their respective office were contrary to, in violation of, and ultra vires the Constitution. 4, an order of mandamus directing the Secretary of the Police Service Commission, requiring the said Secretary to prepare formal letters to the ranks named in the official list of promotions, complied and signed by the Commission on June 28, 2021, informing the ranks of the Commission's decision to promote them and of the particulars of their respective promotions. 5, an order of mandamus directing the Secretary to have a government order prepared giving effect to the said promotions and to instruct the principal personnel officer to publish the said government order. 6, an order of mandamus directed to the Commission of Police requiring the said commissioner to cause a special promotion order to be prepared, informing those ranks listed for promotion on the said promotions list. 7, an order of mandamus directed to the Commissioner of Police requiring the said commissioner to give instructions to the quartermaster to issue the newly promoted ranks as set out in the promotions list with their respective badges of rank. Since the filing of this case, the issues have been considerably narrowed, taking into consideration the judgment of the Honorable Chief Justice in Aubrey Norton against the AG, as well as factual events that have overtaken some of the reliefs sought in these proceedings. In the circumstances, much of the reliefs set out above in the fixed date application cannot be granted and have now been rendered otiose. The single remaining issue for determination is whether the decision to suspend was lawful. However, before proceeding to a final determination of this action on the substantive issue, I wish to reiterate that there were 4 preceding interlocutory rulings following applications filed by the AG and Mr. Ramdani, and arguments taken and written rulings delivered. One was successfully appealed to the full court. The completion of those interlocutory matters has now paved the way for a final ruling today on the substantive issue, that is, the merits of the decision to suspend and whether it was lawful or not. I will not repeat those 4 interlocutory rulings today in any great detail, since they will be reproduced in full in the written judgment to follow in 4 parts, but I will summarize them now for completeness. The first interlocutory ruling on the removal of His Excellency the President as a party from the proceedings. On the 27th of July 2021, a notice of application was filed to have the President removed from the proceedings, owing to the immunities that attach to the President of the Republic of Guyana by virtue of Article 182 of the Constitution. On the 17th of September 2021, after hearing arguments, I ordered that the President be removed on the basis that it was impermissible and wrong to add the Executive President of Guyana to court proceedings, given the immunities that attach to his office. This conclusion is in line with recent dicta of the CCJ in Williams against Pratima Kisoon, a decision delivered recently by the CCJ in which Article 182 was also mentioned. I also held that the removal of the President does not in any way affect the substance of the applicant's case, challenging the decision of the President to suspend, because the state's legal representative, the Attorney General, was still a party to the proceedings. The second interlocutory application. This was an application to strike out the proceedings. On the 16th of September 2021, an urgent application was filed by the Attorney General to have the fixed date application struck out on the ground that the Police Service Commission was vacant. The term of office of everyone had come to an end, and therefore the proceedings could not lawfully be maintained. Having considered all the arguments of the parties, I ruled that the vacancy of the Police Service Commission had no effect on the ability to maintain these proceedings, and it could continue before me after substituting Slowe for the PSC. Moreover, as these proceedings were judicial review proceedings directed at the lawfulness of the decision and not the parties, there was no lis inter partes. Dissatisfied with my decision, an appeal was filed to the full court, and a ruling was handed down on the 25th of May, 2022. The full court upheld my decision not to strike out the claim. The full court permitted Paul Slowe to be added as a party, but did not find it necessary to substitute him in place of the PSC. The effect of this was to have two applicants in the substantive matter, the PSC and Paul Slowe. The third and fourth interlocutory applications was an application by the PSC as newly constituted following the ruling of the full court to withdraw and discontinue the proceedings before me. And the fourth interlocutory application was an oral application for a stay of proceedings due to ongoing appeals in the Aubrey Norton against the Attorney General case. On the 5th of July, 2022, the purported newly constituted Police Service Commission filed an application seeking permission to withdraw and wholly discontinue the proceedings before me on the basis that it was in the best interest of its constitutional mandate to so do. Reliance was placed on the full court decision, which indicated that an appointed commission could determine whether to continue or discontinue the matter. Additionally, an oral application on the 20th of September 2022 by the AG and King's Counsel, Mr. Ramdani, sought a stay of these proceedings pending the appeal of the proceedings before the Chief Justice in Norton against the Attorney General. The decision in Norton against the Attorney General by the Chief Justice, coupled with the reasoning of the full court, made it patently clear that the notice of application to discontinue the proceedings could not be sustained, since it was adjudged in the Norton decision that the PSC was not properly constituted. This therefore meant that the PSC could not actively participate in continuing or discontinuing these proceedings. In fact, the ruling of the Chief Justice in the Norton case crippled that notice of application before me, which was refused by me. It was also determined that the application to discontinue was an abuse of the process of the courts, since it had already been determined that the expiration of the PSC did not bring the live issue of the lawfulness of the suspension to a close. The full court agreeing with this decision on appeal meant that any further attempt through another interlocutory application to achieve the same ends clearly abused the process of the court. The PSC could not withdraw Mr. Slowe's right to have the legality of his suspension challenged. The oral application for a stay of the proceedings pending the appeal in Norton was also refused on the basis that it was an abuse of the court's process. To grant a stay would leave the substantive proceedings before me at an impasse, considering the length of time involved in appealing the Norton decision and the limited nexus between the Chief Justice's ruling and the substantive matter in the extant claim. To permit such a course in the face of the multiple interlocutory applications filed by the respondents, which, like the state, also acted to delay the determination of the substantive issue and would have undoubtedly impeded Mr. Slowe's right to access to justice. It was then ordered that the defense be filed by the 16th of December 2022, affidavit in reply by the 23rd of December 2022, written submissions by the 9th of January 2023, and the matter was adjourned to the 16th of January for oral arguments. I now turn to the substantive issue, whether the decision to suspend was lawful. In doing so, I will first examine the legal nature of the Police Service Commission, which is a constitutional commission. In the case of Endell Thomas against the Attorney General, the nature of this constitutional commission was discussed as follows, and I quote, The whole purpose of Chapter 8 of the Constitution, which bears the rubric the public service, is to insulate members of the civil service, the teaching service, and the police service in Trinidad from political influence exercised directly upon them by the government of the day. The means adopted for doing this was to vest in autonomous commissions, to the exclusion of any other person or authority, power to make appointments to the relevant service, promotions and transfers within the service, and power to remove and exercise disciplinary control over members of the service. Similarly, in the Indian case of Ree against Mehar Singh Saini and Chairman HPSC and others, Justice Kumar Swatantatar stated the following on the autonomy of the Public Service Commission under Article 315 of the Indian Constitution, and he said, and I quote, "The constitutional scheme contained in Articles 315 to 320 noticeably demonstrates not only the complete independence of the Public Service Commissions in the discharge of their functions, but also ensures complete security and protection of tenure to its chairman and members. A very cumbersome process has been provided by the Constitution for the removal of the members, and the chairman. This constitutional intent of ensuring autonomy is underscored by the fact that it is only where the governor of the state makes a reference to the President of India, stating grounds of misbehavior, that the President may remove such a chairman or member, but only after the Supreme Court of India, on a reference by the President under Article 317, reports that the chairman member ought to be removed on the ground of misbehavior. Thus, the immunities enjoyed by the chairman and members of the commission under the Constitution are far greater and cannot be impinged upon by the normal procedure of service law for dismissal of a civil servant under the civil service rules for alleged misconduct. The removal process contained in Article 225 guarantees security of tenure to the chairman and members of the commission to safeguard them against motivated or wrong charges of misbehavior. The obvious intent behind the same is to protect them from undue political pressures or personal favoritism and vendetta, thereby enabling the service commissions to discharge their constitutional obligations in full measure. In the case of Ramkumar Kashyap against the Union of India, 2008, the Indian Supreme Court stated in paragraph 11, "The Public Service Commission is an institution of the utmost importance created by the Constitution of India under Article 315. For the efficient functioning of a democracy, it is imperative that the Public Service Commissions are manned by people of the highest skill and irreproachable integrity, so that the selections to various public posts can be immunized from all sorts of extraneous factors like political pressure or personal favoritism, and are made solely on considerations of merit." In Special Reference Number 1 of 1997, 2004 SCC 309, the Supreme Court of India discussed the role of the members of the Public Service Commissions and made the following observations with regard to their duties and qualifications. In keeping in line with the high expectations of their office and the need to observe absolute integrity and impartiality in the exercise of their powers and duties, the chairman and members of the Public Service Commission are required to be selected on the basis of their merit, ability, and suitability, and they in turn are expected to be models themselves in their functioning. The character and conduct of the chairman and members of the commission, like Caesar's wife, must therefore be above board. They occupy a unique place and position, and utmost objectivity in the performance of their duties and integrity and detachment are essential requirements expected from the chairman and members. The credibility of the institution of Public Service Commission is founded upon faith of the common man on its proper functioning. The faith would be eroded and confidence destroyed if it appears that the chairman or the members of the commission act subjectively and not objectively, or that their actions are suspect. Society expects honesty, integrity, and complete objectivity from the chairman and members of the commission. The commission must act fairly, without any pressure or influence from any quarter, unbiased and impartiality, so that the society does not lose confidence in the commission. The high constitutional trustees, like the chairman and members, must forever remain vigilant and be conscious of these necessary adjuncts. On the 19th of May 2021, the second applicant was charged with the offense of conspiracy to defraud contrary to the common law. The Prime Minister caused a letter to be sent to the second applicant on the same day, the substance of which was to demand that he show cause as to why he should not advise the President that the question of his removal as chairman should be investigated. On the 31st of May 2021, the second applicant gave the Prime Minister prolix submissions in response to the show cause letter. On the 1st of June 2021, show cause notices were issued to members of the Commission to show cause in writing why the Prime Minister should not advise His Excellency the President to initiate an investigation into the removal of each of the members of the Commission. By letter dated 15 June 2021, the Prime Minister advised the President that the question of removal of the applicant as chairman of the PSC should be investigated. In the last paragraph of the correspondence, the Prime Minister also advised that the second applicant be suspended. By letter dated 16 June 2021, Paul Slowe was suspended from his constitutional post by the President, acting pursuant to Article 210(3) of the Constitution. Summary of the applicant's case, or the second applicant's case, Mr. Slowe. As I reiterated, much of the orders and declarations sought in the fixed date application have been overtaken by events of the ruling in the Orbit Norton case. It was submitted on behalf of Mr. Slowe that the PSC is an independent constitutional commission established and constituted in accordance with Article 210, and the procedure employed by the President in suspending him was ultra-vires and unconstitutional. It was further contended that the office of Executive President is established pursuant to Article 89 of the Constitution, while Article 99 of the Constitution vests executive authority in the President, who may exercise it personally or through subordinate officers. The authority that resides in the office of Executive President does not permit the President to interfere or intrude on the independence of the Service Commission, except in the manner prescribed by the Constitution itself. In this regard, reliance is placed on Article 8. It was further contended that it is Article 225 which prescribes the exact method for suspension and removal from office. Council then directed the court to Article 210 of the Constitution generally. Issue was taken with a letter sent under the hand of the President on the 16th of June, which purported to suspend the members of the Commission pending the establishment of the tribunal. It was advanced that the President was enjoined to establish the tribunal in the manner prescribed in Article 225 before moving to suspend. Council submitted that the tribunal referred to can only be set up by the President, acting on the advice of the Judicial Service Commission. Council argued that Article 2254 enjoins the President to appoint the tribunal in accordance with the advice of the Judicial Services Commission, but there has been no Judicial Services Commission since 2017. Council further submits that Article 225(6) of the Constitution is clear in its requirement that an officer may only be suspended from office after the question of removal has been referred to a tribunal under 225. Therefore, the President had no authority to act as he did in ordering suspension. The respondent's defense. The Attorney General has placed heavy reliance on the charges that were instituted against the chairman and another member of the PSC as justification for their suspension. It was further contended by the Attorney General that the power to suspend resides in the President, and owing to the peculiar circumstances of the case, the President's power pursuant to Article 225(6) could not be vitiated due to the absence of a duly constituted Judicial Service Commission. It was put on record that the President had at the forefront of his mind the continuous corrosion to the integrity and independence of the PSC and or the appearance thereof, as well as the public interests, national security, and good governance. To this end, the doctrine of necessity was invoked to justify the President's actions. Against these competing arguments, it is reiterated that the uncomplicated single issue that falls for the court to assess is simply whether the suspension was lawful. I now turn to a discussion on the doctrine of necessity. In Mitchell against the Director of Public Prosecutions, the Grenada Court, off the heels of a violent coup d'etat, had to determine whether an unlawful government could establish a valid court by virtue of People's Law No. 4. The President of the Court, Haynes, authoritatively pronounced on the doctrine of necessity and delineated in instructive detail when the doctrine could be invoked, and I quote. He said, 3, I would lay down the requisite conditions to be that A, an imperative necessity must arise because of the existence of exceptional circumstances not provided for in the Constitution, for immediate action to be taken to protect or preserve some vital function to the state. B, there must be no other course of action reasonably available. C, any such action must be reasonably necessary in the interest of peace, order, and good government, but it must not do more than is necessary or legislate beyond that. D, it must not impair the just rights of citizens under the Constitution. E, it must not be one with the sole effect and intention of which is to consolidate or strengthen the revolution as such. 4, it is for this court to pronounce on the validity, if so, of any unconstitutional action on the basis of necessity after determining as questions of fact whether or not the above conditions exist. But it is for the party requiring the court to do so to ensure that proof of this is on the record. And 5, such validation will not be a once-for-all validation, so to speak. It will be a temporary one, being effective only during the existence of the necessity. If and when this ends, the right constitutional steps must be taken forthwith, that is, within a reasonable time. In the case of Trotman against the Attorney General, 2006 Civil Appeal number 79, Justice of Appeal Cummins Edwards, as she then was, applied the doctrine of necessity to save the actions of the President in appointing members of his cabinet when he failed to convene Parliament within the constitutionally prescribed timeline. In coming to the decision, reliance was placed on the interplay of the amendment to Article 61 and the ensuing elections, which meant that Article 69(1) of the Constitution would have been breached. Since the convening of Parliament was outside of the 4-month period stipulated in the Constitution and thus ultra vires the Constitution, the doctrine of necessity would have to be invoked to validate the President's actions. Further, the events in Guyana after elections were viewed as having constituted a constitutional crisis, since the intervening 4-month period after elections made it impossible to complete all arrangements incidental to the convening of Parliament. Article 210(3) of the Constitution expressly provides that all the provisions of Article 225 which relate to the removal from office shall apply to the office of an appointed member of the Police Service Commission. That article then delineates who are the prescribed authorities for the purposes of removal and/or suspension. For the members of the Police Service Commission other than the chairman, the prescribed authority to advise the president on removal is the Prime Minister or the chairman of the PSC. The prescribed authority to advise the president on removal and/or suspension of the chairman is the Prime Minister. Article 225(1) indicates that the office holders to whom the article applies shall not be removed or suspended from the exercise of their functions except in accordance with the provisions of the article. This is, in essence, a provision which constitutionally ensures security of tenure for all the membership of the Police Service Commission. Article 225(4) prescribes that the Prime Minister must advise the President that the question of removing the officer from office ought to be investigated. The framers went at great lengths to outline the constitutional procedure for removal. I will delineate them in an elementary way for the avoidance of doubt. After the question of removing the officer is put to the President by the Prime Minister, the President shall act in accordance with the advice of the Judicial Service Commission in appointing a tribunal. This tribunal is to consist of a chairman and not less than 2 other members. The composition quorum is therefore at least 3 sitting members of the tribunal. The membership shall consist of judges, former judges, and/or attorneys at law having the requisite number of years to qualify them to be a puisne judge in Guyana. Our living constitution intended for the tribunal members to be fair, impartial, and beyond reproach. It is for this reason that the article indicates that its membership can only consist of persons who meet the requirements as set out in Article 225(4)(a). After the tribunal has been duly appointed by the President in accordance with the advice of the Judicial Service Commission, the tribunal must then do its work. It is the tribunal's role to inquire into the matter and report on the facts to the President and recommend whether the officer is to be removed under Article 225 and 210(3). However, even the scope of the inquiry concerning removal is fettered by Article 225(2), which provides that the officer can only be removed for inability to discharge the functions of his or her office, whether by infirmity of body or mind, or for misbehavior. Article 210(3) provides that all provisions of Article 225 which relate to removal from office is to apply to all members. In essence, therefore, removal from office can only be for cause on the 2 grounds specified in Article 225(2). Independence and security of tenure of office is guaranteed. As it relates to the suspension procedure to which the matter at bar concerns, Article 225(6) applies. The President is only enjoined to suspend a member from office, 1, if the question of removing the officer has first been referred to the tribunal, settled by the President in accordance with Article 225(4), and 2, acting in accordance with the advice of the prescribed authority. It is only after the President has done what is mentioned in Article 225(6) that he may suspend the chairman or members from the Commission. Notably, the President can revoke the suspension at any time, but similarly must only revoke the suspension in accordance with the advice of the Prime Minister. Importantly, Article 225(6) indicates that the suspension of the President will cease to have any effect if the tribunal recommends to the President that the officer should not be removed. Therefore, the President does not have an unfettered discretion to suspend, as his suspension powers only exist on the advice of the prescribed authority and or a decision of the tribunal after the question of removal has been referred to the tribunal. It is to the independence of these constitutional office holders that they ought not be easily dismissed, removed, or suspended, except in the manner prescribed by the Constitution. Having thoroughly delineated the procedure for removal and suspension, it seems apparent that the framers of the Constitution, in their infinite wisdom, sought to create a mechanism which ensured due process and security of tenure so that the membership of the Police Service Commission could not be easily subject to arbitrary behavior. The removal and suspension procedure set out in Article 225 attempts to insulate the PSC from any undesirable political influence. It offers its membership the opportunity to do their business of appointing, transferring, removing, disciplining office holders who fall under their purview without having to keep a watchful eye on the mandates and directives of the executive. This view has been supported by your lordships of the Privy Council in the N.L. Thomas against Attorney General decision, which examined the Trinidad Constitution, which has a similar insulation of its constitutional commissions. Such constitutional commissioners enjoy independence and security of tenure similar to judges in our Constitution, which is a living document and is always interpreted and construed purposively. Constitutions are as revered and sacred as the Ark of the Covenant, and lip service must not be paid to them. In the instant case, the question of removing any of the officers was never referred to a tribunal appointed by the President on the advice of the Judicial Service Commission. This failure by the President proves fatal, as a referral to the tribunal is a conditioned precedent to suspension of members. Therefore, the President had no authority on which to suspend either the chairman or any other member of the Commission. However, the state has sought to be clothed by the doctrine of state necessity or implied mandate to cure the extra constitutional act of the President, averring that the President could not have acted in accordance with the advice of the Judicial Service Commission because the Commission was not duly constituted. It is my considered view that the failure to constitute the Judicial Service Commission cannot be relied upon to excuse the unconstitutional act of suspending these constitutional office holders. The failure to constitute the Judicial Service Commission is the President's burden to bear. All members of the Judicial Service Commission are appointed by the President after he has meaningfully consulted with the relevant constitutionally prescribed functionaries. In these proceedings, no evidence was adduced which would indicate that the President took steps to constitute the Judicial Service Commission. The framers of our Constitution envisaged constitutional compliance, and that all constitutional commissions would be duly constituted, and those which were not, haste would be made to do so. This is so because a failure to duly constitute a constitutional commission operates to negatively impact the machinery and administration of government's work. Constitutionalism implies constitutional compliance, which is an indispensable prerequisite to a modern constitutional democracy. The authorities make it clear that the doctrine of necessity or implied mandate is invoked at times when it is necessary for the executive or some other body to act in order to maintain the proper functioning of various arms of state. It is invoked under the aim of maintaining or ensuring stability. The concept is that that which is not lawful is made lawful by necessity. The failure to appoint a commission, in my view, does not meet the high threshold to invoke this seldomly utilized doctrine. Our country has taken pains not to invoke the doctrine of necessity. The case of Trotman against the Attorney General appears to be the only case in which it was successfully invoked to save the unconstitutional actions of the president. Indeed, in Christopher Jones against the Attorney General and Clifton Hicken, Chief Justice Roxanne George took great care in explaining why she would not invoke the doctrine when the president failed to meaningfully consult with the leader of the opposition when that post was vacant. The Honorable Chief Justice noted that the doctrine of necessity was applicable in only exceptional circumstances. However, there was a necessity placed on the president to act in his own deliberate judgment in appointing an acting police commissioner. The Honorable Chief Justice saliently proffered the following words, and I quote, "Indeed, the doctrine appears to be applicable to exceptional circumstance. For example, where there is such political upheaval in a country which does not permit adherence to the Constitution. See Mitchell against the DBP 1986. The doctrine only applies to safe actions that have been carried out in contravention of the co-national provisions or other legal requirements. While I agree that there was no extreme situation of emergency that led to a suspension of the Constitution or any of its provisions, on the facts of the case at bar, in the absence of a leader of the opposition to meaningfully consult with, I am of the view that out of necessity, the president could have acted and it was reasonable for him to take action in his own deliberate judgment pursuant to Article 111 to address the unexpected circumstances of this case. There could have been a negative impact on national security if the highest office of such an important law enforcement agency was left vacant. For what on the situation as it stood at March 30th, 2022 were circumstances of uncertainty. There was uncertainty not only because the Police Service Commission was not in being since August 8, 2021, but because for some 3 months since January 26, 2022, a leader of the opposition had not been elected, and it was unclear when such an election would have offered. Suspension is a serious disciplinary mechanism that carries with it enormous consequences, such as loss of income, as well as immeasurable intangible loss, such as loss of public confidence and reputation. And great care must always be taken before embarking on that exercise. Fidelity must always be paid to the Constitution, rule of law, and natural justice. Such a course was abandoned in this case. The state, by invoking necessity, has admitted to this faltering course. However, necessity can be of no aid in the circumstances at bar. The state has not convinced the court that this was an extreme situation which warranted the utilization of the doctrine of necessity. There was no political upheaval. There was no instance of societal breakdown. There was no suspension of the Constitution. The extreme circumstances which resulted in a failure to comply with the provisions of the Constitution by the President was as a result of the actions of the President in not appointing a Judicial Service Commission. Counsel for the State, the Attorney General, has leveled that the President was enjoined to act in the interest of the nation by virtue of the charges that were pending against the second applicant and a court action which the applicant had joined, which was of a perceived political flavor. However, the President only acts in a preliminary way on a prima facie subjective view, which is subject to an objective inquiry by the tribunal, which encompasses all the rights due to the suspended office holder, including the protection of the law and due process. On the issue of the criminal charge, lest we forget, in this republic, there is an enshrined principle backed by constitutional muster to which every citizen of this country is afforded, and that is the right to the presumption of innocence as set out in Article 1442. of the Constitution. Mr. Slowe has not been convicted of any charges. At the time when he was suspended, he was entitled to that presumption. The mere institution of criminal charges cannot amount to misbehavior except and until the person has been adjudged by the competent tribunal. Therefore, the act in reliance of the charges alone cannot be a basis to justify the president's decision to suspend. In light of all the considerations aforementioned, I am of the considered view that exceptional circumstances do not exist to invoke the doctrine of necessity. Consequently, the decision to suspend in the absence of a referral to the tribunal was ultra vires Article 225 and unconstitutional. Since Paul Slowe and the other commissioners could only have been removed from constitutional office for cause on the aforesaid two grounds for removal, it is axiomatic that they were and are entitled to their constitutional rights of protection of the law and due process. The suspension of the chairman and other members in the absence of a Judicial Service Commission and constituted tribunal was a nuclear response by His Excellency the President. The suspension proved permanent and tantamount to a removal from office without due process. The Constitution imbued the President with no power to suspend in the absence of a tribunal, and in doing so, he acted ultra vires the Constitution. A condition precedent to the executive power to suspend is a referral to an establishment of said tribunal. This is a sine qua non to suspension and removal. The President acted on a prima facie subjective view, which ultimately has to be validated by an objective tribunal after a hearing where due process is observed. This court, sitting in its supervisory jurisdiction in a judicial review case, is not concerned with the merits or demerits of alleged misbehavior of the constitutional office holders. That is a function of the tribunal. This court can make no conclusive finding of fault because this is not its function. This function properly belongs to the tribunal. It is not my function to conclude whether there was political contamination of the PSC as alleged, or whether they were guilty of misbehavior. This court is only concerned with the lawfulness of the decision to suspend and whether that power existed. The tribunal is the constitutional safeguard to the President's decision. Were this not so, then this would open the floodgates for executive action to suspend other constitutional office holders on a prima facie subjective view without due process and without cause. The applicant's constitutional rights to the protection of the law and due process cannot be emasculated, excused away, or rendered nugatory because there is no tribunal. Were the tribunal in existence, the applicants would have been entitled to due process and their full panoply of rights before it. The right to due process is a constitutional right and is not abrogated due to the non-existence of the tribunal. Surely the right of due process envisages the expectation and existence of the tribunal. The non-existence of the tribunal left the applicants perpetually suspended. An extension of this—
Sorry, I'm having trouble connecting to the internet. It looks like an issue with the router and echo device, so try restarting them. Unplug both of them, then plug the router back in. Wait 30 seconds. Once the router—
I was given a brief opportunity there to take some water by my Alexa device. My apologies. The right to due process is a constitutional right and is not abrogated due to the non-existence of the tribunal. Surely the right of due process envisages the expectation and existence of the tribunal. The non-existence of the tribunal left the applicants perpetually suspended. An extension of this unhappy situation would be a scenario where a citizen has offered a grievance and is unable to come to court for redress because the court is not in existence. It may sound absurd, but this is a logical extension. The existence of the tribunal is contemplated by the Constitution and required within the context of the applicant's rights to the protection of the law and due process. In its absence, the applicant's right to due process has been rendered nugatory by executive action. This is unlawful, unconstitutional, and a breach of the Slowe's right to the protection of the law. In summary, therefore, the decision of His Excellency the President to suspend the chairman and other members of the commission was unlawful, ultra vires Article 225 of the Constitution, arbitrary, unreasonable, unfair, in violation of the suspended chairman and commissioner's constitutional rights to the protection of the law and due process of the law. It is also consequently null void and of no legal effect. It is hereby ordered and declared that judgment be and is hereby granted in favor of Paul Slowe as prayed for in paragraph 1 of the fixed date application. That is my ruling, and I'll ask the parties to address me on the issue of costs.
Good afternoon, Your Honor. Mr. Todd will be addressing the court on the issue of costs, and I think we'd asked for time to make submissions because this case has taken a significant amount of time, and the cost will be very significant that we'd be asking for.
So you're asking to put submissions in writing in relation to costs?
Yes, Your Honor, because this case is, as you know, this case has been before you since 2021 and it's 2023, and there've been numerous appearances, numerous submissions, and we'd like the opportunity to certainly put before you the cost factor that has got into this case, and so that it's not something that we're just telling you off the top of our head. It's something that's carefully considered and put before you.
Attorney General's chambers.
Your Honor, we will join in the application of Mr. Peters to put in submissions on each of.
All right, so the parties to exchange written submissions on costs. How much time?
Your Honor, we'd ask for 20 days.
Millard, before you put your directions in writing, may I be permitted to briefly address you on that very issue, Millard?
Go ahead.
Millard, I appear, as you know, for the Secretary to the Commission. Having regards to all that has transpired, Millard, and all of the preliminary applications, and now that I have listened to your judgment, it would seem to me, Millard, that the Secretary to the Commission really should have not been any part of these proceedings at the end of it. There might have been reasons for him to have been in the beginning, but not at all having regards to your detailed judgment that you have just read out, Millard. And so I would ask that even now that you perhaps can agree to that, and so that he doesn't have to make any submissions in relation to cost at all. He should not be burdened with any of that.
All right. Well, the AG's chambers and Mr. Peters, you'll put your submissions in writing by the 14th of April. If Mr. Ramdani does not wish to put any submissions in, that's okay. And I'll have a look at the submissions filed by both parties. And I'll arrive at a decision.
Just for clarity, Miller, I am hoping that you are in agreement with what I have just said, that there will be no cost order made against the secretary having regards to the way these proceedings evolved and where your judgment ultimately is. I don't want not to be putting in submission and then find that
well, it's not a decision that I'll make without considering all the submissions by all the parties. So if you do wish to submit on that point, you're certainly allowed to, but I would like to have everyone's submissions before I make a final decision on costs, rather than saying no order in relation to costs in respect to you, and then I have to decide in respect to the others. I would prefer to make one decision.
Thank you, Miller. Will do.
All right, so by the 14th of April. All right, if there isn't anything else, thank you very much.
Thank you.
Thank you, Ryan. Thank you.
Please, Your Honor.
Well, you guys heard everything there. We'll take a quick break. Congratulations to Paul Slowe and his team. Congratulations to the people of Guyana. This is what you call real justice, real case,
Recording
real
stopped.
decision. We'll be right back.
People, let's get together. Stop all this fussing and fighting. Let's love one another. You gotta help your mother, help your father, help your brothers, help your sisters, help your neighbors and your friends. We are one people, one nation, one destiny. Everybody, y'all. One people, one nation, one destiny. Yeah, yeah. Separated. Now we are freer. That's the way it should be. You gotta help your mother, help your father, help your sister, help your brothers, help your neighbors, and your friends. We are one people, one nation, one destiny. Yeah, yeah. One people, one nation, one destiny. Oh, 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 oh. Yeah, 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 yeah. Ooh, we are one people.
All right. Hey, guess what? You guys heard that case there. You heard everything in its entirety. The congratulations to Mr. Paul Slowe. We were hoping to have Mr. Paul Slowe here, but Paul is definitely preparing to be on his own platform sometime later on, I believe, and we can understand and respect that. Selwyn Benjamin is asking, where's the mainstream media? You won't find the mainstream media with these sort of things, right? Okay. And so this is a case the Police Service Commission, along with Mr. Paul Slowe, the then chairman of the Police Service Commission, was illegally removed by Irfan Ali and his gang. And this is what this court proceeding was all about. And victory to Mr. Paul Slowe and his team. It offers hope. It offers hope for Guyana, especially when you see justices that are sitting there and interpreting the law, because that's the judicial branch. That is what they're there for, to interpret the law how it ought to be interpreted. And I do believe, and almost everyone will agree with me, that Justice, still acting justice, Gino Prasad, made a solid decision by virtue of what is in the Constitution and what the law requires of him. And this is exactly what is needed in Guyana to restore hope, to restore credibility in the judiciary in Guyana. And I think today, the Honorable Acting Justice Gino Prasad has always been consistent with rendering his decision or his decisions without any sort of biases. And I was chit-chatting with a friend during the course of the hearing. I suspected that maybe the friend was getting a little agitated and a little impatient because of the length of time the decision took to be made. And I had full confidence in Justice Gino Prasad, and I'll just read to you what I said to the individual. And the individual wasn't thinking what I thought that person was thinking. And I said, regardless of this judge's decision, I would respect it. And so even if Justice Gino Prasad had gone the other side in terms of the decision, I would have respected that decision. But any reasonable judge would have ruled in the exact manner that Justice Gino Prasad has ruled. Justice Prasad has basically broken every single clause, every section down for the layman to understand. So no one can walk away here feeling as though they didn't understand what happened. And so we got to temper our emotions a little bit. We know how some of you feel. Let's not get too carried away. But let's, and some of you guys know what I'm talking about, but this judge, Gino Prasad, the Honorable Gino Prasad. And you can notice that we have some lighting issue here. I just couldn't get as white as you guys are seeing me here on the screen. And you know, definitely you guys know that Lemon will have to pay the price for this out of his salary this weekend or whenever he gets paid through us. He definitely will have to pay for this. But let me read some of your comments as it pertains to this case. Again, Irfan Ali has lost this case. In fact, they had no real case. He was just basically wasting the court's time, wasting taxpayers' money, and all manner of things. And so the decision is basically against Irfan Ali. We're waiting. There's a possibility that he's going to appeal the decision. I would be surprised if he doesn't appeal this decision. I'll be surprised if he doesn't. Usually that's what he does, right? Things that don't go in their favor, they appeal as quickly as possible. And so I'm looking at some of your comments. And I think you guys are on to something. But let us remain focused and not allow emotions to get the better part of us. There will be decisions by judges that will be sound in law. Sound decisions that will be sound in law. And there will be decisions by judges that are questionable. There will be decisions by judges that are politically aligned. But today, what we saw and what we heard is a decision that is sound in law. And whenever you have judges making decisions, rendering decisions that are sound in law, it simply means that we are seeing that light at the end of the tunnel. It is offering the citizens of the country a great degree of hope that there is hope. There is hope for Guyana with professionals such as Justice Gino Passad. And it is just what it is. I know a lot of you are happy, especially with cases, and we're still not getting this light properly fixed, but it doesn't mean that I'm sure that you guys can still see me, right? And it's not like you need a torchlight. But I know over the past months or a couple of years, there were decisions that made you guys feel very uncomfortable, that decisions that made you guys feel lost, made you guys had no hope in terms of the judicial system. And we're still trying to fix the lighting, and hopefully we'll get it fixed so that some of you won't complain that I'm bleaching and all manner of things. You guys see the kind of insult that I got to get from y'all, right? Oh, Mark is bleaching, Mark, all manner of things you guys do to me. But, it offers some hope, and we want our judicial offices to function just as the manner in which acting Justice Gino Passad just demonstrated. Congratulations again to Paul Slowe. I've invited Paul to be on with me for a few minutes, but Paul is in that celebratory mood, probably taking lots of phone calls and so forth, is all happy about this decision, and rightly so, because there was no due process, there was nothing at all, absolutely nothing. And then it is so wrong that they would drag a man before the court without due process and attempt to besmirch his character. And that's exactly what they did. The judge did the honorable thing. We're trying to get a legal view. We're hoping, like I said, Mr. Slowe is enjoying the moment, and rightly so. We're not sure what his attorneys are up to, but maybe we can attempt to get in touch with one of the attorneys and see what transpired. Forgive me. I'm still. I promise you guys that this is the lighting, and it's the lighting from the camera. We're trying to get it fixed, but let that not be any sort of distraction to you. Let's focus on the bigger picture. Let's focus on the brighter side of things, and not whether I'm. I notice some of you guys are so concerned about me. My friend all the way in Amstel, Rhonda Lane, is saying, Mark, it may damage your eyes. Thank you so much, Rhonda. Rhonda is such a caring person. I bet when I'm in Guyana, I'll be visiting Rhonda because I want Rhonda to prepare some nice fufu for me. She looks like she can cook a good cook-up. Or a metemg. I haven't had that in a while. Metemg. Ram Singh, good afternoon to you, my friend. And all of you guys, Brenda Moore and the entire crew who are watching. Let's see if we can get a quick comment. It's 2:47. we may be able to spend a couple of minutes more and see if we can get a couple more, a few more comments. I'll be on tonight at 9 o'clock, definitely. You can't miss me. These days I'm on, right? Yep, these days I'm on. Folks are saying great job, Selwyn Peters and his team. Indeed, great job. Selwyn and I have had our little rumblings in the past and so forth. But it is what it is sometimes. We get along, we agree sometimes, and sometimes we don't agree. But I've noticed that Mr. Selwyn Peters, along with Roysdale Ford, the Member of Parliament Roysdale Ford, and he's also senior counsel. There we go. We're back to square one, right? Thank you. Nicole Cole, good afternoon. How are you? Nicole is still with the doctrine of necessity cannot be used by, okay, Nicole. We got it, Nicole. Nicole is always ahead of the game, That's why I like when I'm in Guyana and we stand up and we're fighting against injustices. Nicole is always passionate about these things. Some of you may not know Nicole, but Nicole is one of those brave fighters. She never give up, and she's very, very fair and objective, in my opinion. All right, we will be joined shortly by an attorney, our in-house attorney, to solicit her quick response to this ruling. And we're hoping to get Paul Slowe, but like I said, we will forgive Paul. Paul is definitely should be celebrating after all what they put him through. You guys know what they put him through. Try to embarrass him in every way. And lots of prayers, and Paul has been getting a tremendous amount of support from folks like you out there, and support from people, Guyanese and possibly non-Guyanese throughout the world, because they have seen this as an injustice. And this is not the only case where the injustice and the persecution is blatant. They have other cases, and we have mentioned those other cases right here on 107.1 FM. We have been very consistent in hitting this for where it is, and reminding you guys that these folks are also being persecuted, and we want fair. We want judges and magistrates who will interpret the law without any sort of prejudice or political affiliation or whatever, just as we saw moments ago coming out of the courtroom of Justice Gino Prasad. And there are many folks who are being persecuted, but if the law is to be applied, these charges, these trumped up charges such as acts of terrorism and so forth, would not see the light of the day in any court in Guyana. But because of judges operating and magistrates operating, some of them, mind you, I'm not going to paint all with the same brush, but there are some judges and magistrates who are operating under duress. Some are operating as political operatives, and others are extremely independent. It is the independent judges and magistrates that will lift the country up from where it is. And we have seen that today, in today's ruling. We have seen that. And again, we want to applaud this judge. And like I've said to a friend of mine, that regardless of the decision today, I know that it would have been a fair decision coming from this honorable member of the judiciary in Guyana. And I am pleased that justice has prevailed. It has been over 2 years, and Paul Slowe finally got his day in court, and he's victorious. Thank you. We also know that these guys are not going to be too happy. Irfan Ali, the installed president of the Cooperative Republic of Guyana, is not going to be too happy, and it's not like we are too bothered about that. It's not like we care about that. Anil Nandilal is not going to be too happy as well because he seems to have he's been losing so many cases these days, and this is becoming more or less an embarrassment. If I were Anil, I probably would have taken a nice vacation up the Berbice River or somewhere and relax. Just relax for a moment because it's not looking good. All right, let's head over to Attorney at Law, Miss Washington. Miss Washington, I'm not sure whether you got to hear the case. Justice Gino Prasad, Acting Justice Gino Prasad, has ruled in favor of Mr. Paul Slowe, and moments ago, I guess your volume, yeah. But moments ago, he ruled that Mr. Paul Slowe, an injustice was meted out against Mr. Paul Slowe and others as they were incorrectly removed from the the Police Service Commission without due process. Assuming that maybe you heard a little piece or whatever, what is your take on this decision, ma'am?
Mark, as you can see, I am smiling because I feel kind of overwhelmed with joy that they're actual judges like Gino Prasad. I know who Gino Prasad is. I think he was 1 year or so above me in law school, at Hewlett in law school. And having judges like Gino Prasad gives me hope for Guyana, because one of the things that makes a democracy very strong is the ability of the judiciary to remain independent of any sort of corruption or wrongdoing when it comes to political leaders. And to find that there's a judge that would stand up for what is right and do justice, this sort of things I think would make anybody a little bit happy, and there'll be some sort of feelings of hope, some sort of feelings of satisfaction that, hey, justice is being served, and there's somebody who's willing to stand up and said, if due process is not served, then the action taken by any government, taken by any person against a person without any due process is wrong. So I'm kind of pleased with this decision.
Absolutely. And as I was saying moments ago, that these are the decisions that which are sound in law. This is how the Constitution, this is how the laws of Guyana should be interpreted by our judicial officers.
That's right, Mark. Words is not enough for me to express how happy I feel right now that we actually have judges like Gino Prasad in Guyana who will stand up for what is right and what is just, and to say no to corruption, to say no even though the ruling might be adverse against political leaders. I think this is the thing. Justice must prevail at all costs. And like I said before, this makes for a very healthy democratic society when we have judges doing the right thing, standing up for the law and enforcing the law correctly. We know as attorneys and judges knows that no one should be deprived of property or liberty without due process. And I think this is well deserved. This is very, very well deserving. And I congratulate Gino Prasad on a job well done on enforcing the law correctly.
And this is exactly what we need. I noticed that someone is asking here, this is a relevant and an important question here. So what about the offices that were promoted last year? If the removal of Mr. Paul Slowe and others, of course, we are understanding the ruling to be that it was illegal, and therefore the promotion of those offices, your take?
Absolutely, Mark. If ruling comes out to say that somebody was wrongfully removed from a position, it means it has to be reverted to the original position that they were in. So, meaning they were never removed, and whatever position Paul Slowe was in prior to being illegally removed from his position, he reverts back to that very position until otherwise decided or correctly decided. the action taken against him was wrong, legally wrong. He had to, there should have been a process. They should have gone through whatever procedure there is based on the Police Act or any statutory guidelines of how police should be removed from office, or any public officials should be removed from office. And if that was not followed, Gino Prasad rightfully ruled that it was illegal. It was an act that should not have taken place to begin with. So Mr. Slowe would have reverted back to his original title. His position would still be intact, and his pay, he would have to receive retroactive pay for any pay that he was deprived of. And that means his pension also is still intact. And whoever was promoted to that position is not rightfully occupying that position, because it tells you that if an original act was wrong, every single act that follows it is also an act that is not correct. So if Paul Slowe is still in that position, any officer who subsequently promoted to that position has to be reverted back to where they were.
Absolutely. Good point, dear. Attorney at law, Shellen Washington, based in New York, office out there on Utica Avenue. A beautiful day in Brooklyn. Utica Avenue must be very warm right now, especially with this decision here.
I know, Mark. This is reason to celebrate. This is cause for celebration. We look and we see justice being served on a platter in Guyana. I'm surprised and happy.
And it's Friday. Maybe I should hop by your office there, meet with your team and everybody there, and drink a glass of Mobby, actually. But
yes.
On a serious note, though, the fact that this judge, one of the things that really kind of put that smile on my face, other than the decision, is the fact that, and I've noticed somebody mentioned that he kept reminding us, or reminding those in the court, about the Constitution, the founding or the framers of the Constitution. And this guy, it seems as though he, and with no disrespect to the Honorable Acting Judge, Justice, it seems as though he studied that Constitution inside out, or he swallowed that Constitution. The way in which he interpreted that Constitution makes me feel proud. I just wish other justices would just, when they rule, when they make a decision, to go directly to the Constitution.
Absolutely, Mark. And you see, that's what makes, and that is exactly what differentiates a good attorney from one who is just going through the motion, or is just doing this, or sitting on the bench as a judge just for being there for political reasons, or for their own personal agenda. What differentiates a good attorney is one that is able to go back, reference the law, and apply it to the facts. And if the learned judge is able to go to the Constitution, understands it, and apply it to the factual situation, I think that's excellent. I think he did a really great job in applying, because we know that you cannot, this is strike law. In America, we say black letter, that you cannot deprive a person of liberty or property without due process.
I was gonna, you preempted that, because the judge did emphasize on that very term. Due process was denied. How can you bring somebody before the court, remove somebody without due process? Touch on that, please.
Absolutely, Mark. I mean, for those people who don't understand what due process is, it just means that if you want to take something from someone, there is procedure under the law. The law states you must follow those steps in order to deprive that person, which means there must be like a hearing, either administrative hearing, or it could be one through a court, where you take evidence to determine whether the person infringed or violated some sort of provisions of the law, or whether or not, if it's not statutory, it could be constitutional, or wherever those provisions are, the person have to have done something to cause you to put them through a process, a hearing, to determine whether or not they should be deprived of some sort of liberty or property. In this case, it would have been depriving Paul Slowe of his property, his pension, his job title. So I don't know all of the circumstances under which he was forcibly removed from office, but I do know the learned judge is actually really correct. And like I said, This is what makes a judge a good judge, his or her ability, or even an attorney, his or her ability to read, understand the law, and apply it correctly, not just apply it, but correctly apply the law. And this is no stranger. Due process is no stranger to any person who have practiced law. You've studied the law. You're a judge. You're an attorney. You know what due process is. And no president, which that's what makes me even more proud, that the political administration should not engage in such practices. And we need more judges like Gino Prasad, who is going to enforce the law when litigants come. And this, like I said, this is what makes a country a good democracy. Its ability to have the judiciary stand independent of all political pressure, so that the president, the attorney general, no one should be able to put pressure on any of the judges or interfere with the judge's ability to apply the law fairly and correctly. So
we have seen a lot of that interference by Mike Pompeo, the then Secretary of State, but we'll touch on that probably some other time. I know how Guyanese are. They love Justice Gino today.
Oh, yes.
Justice Gino were to do a ruling that they don't like tomorrow.
I did not know Gino Prasad was now a judge.
Yes, he has been a judge for several years now. I am proud of this ruling. In law, as you should know, Paul Slowe now has the right to commence a civil lawsuit against the state for infliction of emotional distress. I'm showing off. Infliction of emotional distress. Break that down for us, please.
I think absolutely. I think what's going to happen now, they're going to take steps to restore that which he had lost, because it would be foolish on the part of the state or the administration not to take steps to restore to Mr. Slowe's pension, any interest that would have been lost on that pension, any money that is owed to him, including interest for depriving him for a particular period of time of not having that money. I think that goes without saying, and I don't think Paul Slowe should have to approach the court again to have those rights restored to him. I think the state should take action on its own volition to do what is right.
Not to cut you, I was going to say honorable judge, but who knows? I wouldn't walk back on that. I refer to you as a judge. You never know, Miss Washington. But the state is not going to lay down taking this like that. ANIL, knowing how they operate and as arrogant as they are, this is, in my opinion, going to the appellate court and possibly the CCJ.
Mark, this would be foolish on the part of the state, and I would be very disappointed if the Attorney General would go and try to appeal a decision that is obviously, on the face of it, correctly laid out. If somebody, the Attorney General knows this. He went through law school, so he's aware that you cannot deprive any person of property or liberty without due process. And if this is the ruling of the learned judge, then I agree with it, because you cannot deprive somebody in that type of manner. And to appeal, what would the Attorney General be appealing from? Is something that is
these guys, not to cut, these guys don't care what they appeal. I hope you're right that the matter should be done right now. Mr. Paul Slowe and others should be compensated, and great job to his legal team comprising of Selwyn Peters and others. Miss Washington, before we go. Attorney at law Washington, before we go. It's a Good Friday. It
is, Mark.
I've never seen you smile.
Friday.
Yeah. But quickly before we go, though, here's a brave decision, you would say, because I've not in recent times seen any judge in recent time brave enough to make such a decision against someone who sits there as a head of state, a matter as important as this. Some other judges probably would have operated under duress, but not this guy, not this judge at all. Your closing remarks.
Mark, this is why I said before, this is the type of decision that it's very pleasing. It's something that needs to be celebrated, because here's a situation where we see that the law is being applied without fear or favor. And that's the oath we take as attorneys, to apply the law. And as a judge, that's what Gino Prasad has done today, apply the law without any fear or favor. And I would like to see more judges like this in Guyana who will stand up and apply the law without fear of repercussion, fear of anything that might come back. And I think we need to move away from having the judicial system under any political pressure, because I believe judges are appointed. If we have the judges elected, I think we should change the system in Ghana and have judges elected. Because if the judges are elected, then the president has no say in who is appointed. The president would have no opportunity to put any pressure and to try to influence any decision in any way, form, or shape. So I think Guyana should be working towards electing their judges. And today, again, like I said, I'm very proud of this decision. I think it's a job well done by Gina Prasad. And I want to say congratulations to Paul Slowe. And now, if necessary, he can take steps to take any civil suit, which may be possible. I'm hoping he doesn't have to, but I think this is a job well done.
A job well done. We're hoping that he's going to get through the compensation and so forth. The judge is going to make that decision within 14 days once the legal team submits their stuff. I heard one of the attorneys there, who is supposed to be a Queen's Counsel. Gosh, sometimes I wonder, why am I not a Queen's Counsel? And those guys, the way he spoke, I'm like, wow, is he really a Queen's Counsel? And then wants the judge to make a decision so that somebody who sat there for almost 2 years as a party to this case, that guy Ramdani is now a Queen's Counsel, is asking for that person of whom he represents to not pay any compensation to the court. I'm like, what is happening here? But, Ms. Washington, I thank you so much. Persons in the New York area might be watching. They might have a case. What number can they reach your office on right now? Let's give you that plug.
Mark, before I give my number, I want to say thank you again for having me, and thank you to your listeners who are here today. Thanks to all of them for the support they've been giving me from the time I've been here in Brooklyn. My office is located at 455 Utica Avenue in Brooklyn, New York. My phone number is 718-877-3100. Like I said,
you better repeat that number again quickly before we go.
Yes, 718-877-3100.
All right, they can't miss that. Thank you as always. I know you took time out of your busy schedule, and keep the smile on your face. And let's get more rulings like this in keeping with the Constitution and the laws of Guyana. Thank you, Ms. Washington.
That's right. Thank you, Mark.
Thank you so much. And to all of our listeners in Guyana and outside of Guyana, thank you so much for spending that time with us. I'll be back this evening, 9 o'clock this evening. I will have as my guest, I will have Mr. Lincoln Lewis will be my guest this evening. I want to smile. I want to laugh at somebody right now. Have a great rest of the afternoon. See you guys at 9 o'clock this evening. Lincoln Lewis is my guest this evening. Congratulations again to Paul Slowe, and congratulations to his legal team.
Good like this, reggae's another day, y'all. Move, y'all. In the olden days, we were separated. Now we are free, yeah. That's the way it should be. You gotta help your mother, help your father, help your sister, help your brothers, help your neighbors, and your friends. We are one people, one nation, one destiny. Sing my song, yeah. One people, one nation, one destiny. Whoa, whoa, whoa. One people we are, we're one destiny. What we're fighting for, I don't know. Let's keep on living.
So this is attorney Shellen Washington. owner and founder of the Washington law firm located at 455 Utica Avenue in Brooklyn, New York. We're specialized in medical malpractice, personal injuries, matrimonial law, and landlord and tenant. If you're in need of legal representation, please give us a call today. The number to call is 718-877-3100. Consultation is free at no cost to you. So call us today to see if we can be of any assistance to your legal needs. Again, the phone number to call us is 718-877-3100.